Across the United States, reports have surfaced of Immigration and Customs Enforcement, ICE, arresting, detaining, or even deporting individuals who were legally in the country, including permanent residents, visa holders, and in rare but documented cases, even U.S. citizens. As political winds shift, a major question is emerging. What could be the future consequences, legally, politically, and financially, for ICE agents and their leadership if these actions are later ruled unlawful? Today, we break it down. Let's begin with what we already know. Multiple investigations from outlets like the Los Angeles Times, Washington Post, and ACLU have revealed instances where ICE mistakenly detained American citizens, often due to flawed databases, mistaken identity, or racial profiling. Examples include a U.S.-born Marine veteran held for 3 days, multiple U.S. citizens in Florida detained during workplace raids, dozens of legal permanent residents detained despite presenting valid papers. Historically, ICE has avoided serious penalties for these incidents, but the legal and political environment of 2026 and beyond could look very different. If ICE detains or deports someone unlawfully, several laws come into play. 1. Fourth Amendment violations. Unlawful detention can be argued as an unconstitutional seizure. Courts have the power to award damages, open class action litigation, issue injunctions against ICE practices. 1. Civil Rights Act, Section 1983. If ICE officers knowingly violate constitutional rights, they could face civil liability. 1. Federal tort claims. Act wrongful detention and deportation can lead to lawsuits against the government itself. 1. Qualified immunity. Weakening. In recent years, courts have begun narrowing qualified immunity. If a future Congress or White House continues this trend, ICE officers may be personally liable for misconduct. This shift could expose individual agents to lawsuits that were previously very difficult to bring. If Democrats gain control of Congress, or even if bipartisan coalitions form, several consequences could become likely. New oversight committees focused on ICE conduct. Subpoenas, hearings, and investigations could become routine. Mandatory audits of ICE arrests. Congress could require verification of citizenship status, review of all detainment files, release of individuals held illegally, a compensation fund for wrongfully detained individuals. This has been proposed by civil rights groups and could easily gain traction. Limits on ICE databases and use of biometrics. Congress may require independent verification of citizenship, restrictions on multi-agency data sharing, bans on flawed facial recognition systems, criminal liability for willful misconduct. If ICE leadership knowingly authorizes unlawful detentions, lawmakers could push for penalties similar to those used for police misconduct. This could include fines, loss of federal benefits, criminal charges in extreme cases. The political consequences would be enormous. Let's talk specifically about agents. Current protections include federal employment shields, qualified immunity, union representation. But if laws change, and there is increasing pressure to do so, agents could face 1. Personal lawsuits. Families of U.S. citizens who were wrongfully detained could sue agents directly. 1. Decertification. Just like police decertification laws, ICE agents could be barred from future federal employment for civil rights violations. 1. Career-ending administrative punishment. A future administration could strip security clearances, remove pension eligibility, terminate agents who violated policy. 1. Criminal charges for knowingly illegal arrests. If Congress creates new penalties, agents could face prosecution if they ignore proof of citizenship, detain people with valid visas, detain individuals without probable cause. This would mark the most significant accountability shift in ICE history. The repercussions aren't only for individuals. The ICE institution itself could face structural overhaul. Congress may push to merge ICE functions with DHS or localize enforcement. Budget cuts or targeted funding restrictions. If wrongful detentions generate public outrage, Congress could freeze budgets for detention centers, field operations, private contractor facilities. Court-ordered monitoring. Courts could impose federal monitors, data transparency requirements, court-approved arrest protocols. Mandatory training and certification. Agents may be required to undergo constitutional rights training, cultural competency, verification procedures. ICE could be forced into the largest operational restructuring since its creation in 2003. Unlawful detentions deeply impact communities, especially in states like North Carolina, Texas, Georgia, and Florida, where recent raids have disrupted schools, colleges, and workplaces. These incidents may influence Latino voter turnout, suburban moderates, first-generation immigrant families. If wrongful arrests continue into 2026, they could become a defining issue of the midterms, especially in swing house districts where immigrant families make up a significant share of voters. A future Congress may be elected on the promise of holding ICE accountable. ICE agents and leadership may soon face unprecedented scrutiny. As we enter a new political era, wrongful detentions won't simply be mistakes. They could become legal, financial, and criminal liabilities. The big question now is whether lawmakers will act and how accountability will reshape immigration enforcement in America. Stay informed, stay empowered, and stay tuned.